Yes, Ms. Burns.
Yes, my lord and my lady, thank you very much for the time over the lunch and adjournment during which we have called our client. And I just need to inform the court of what she says about the current status of the proceedings in Romania. As far as, there's 3 points really. As far as the exequatur process, so the enforcement of the protective measures is concerned, it is my client's understanding that nothing yet has happened. And over the lunch break, we've been sent an email from the other side, I think, based on information from Lucy Roberts at Walker Family Law, to say that there's been a delay in obtaining a copy of the court order here with a wet seal. And so that's one of the reasons why that hasn't commenced yet in Romania. The second point is that there has been an order which suspends the Romanian case pending the outcome of this appeal. And again, my client herself hasn't been able to provide us with any documentation. I don't know why it hasn't been sent to us by the other side, because it seems that the father has access to this, and I'm told his Romanian lawyer is on the link as well, I think, in this email. But in any event, that is my client's understanding as communicated to me over the lunch break. And then thirdly, I've taken instructions on something which has been sent to us overnight or this morning by the other side, which is a Google translated version of a Romanian document titled Counterclaim, and is a counterclaim submitted on behalf of the mother in the Romanian court. It refers to some of her allegations and wishing to dismiss the case, but then at the conclusion of the document, it requests that the Romanian court place Hakim with her at her grandmother's address. And I have taken specific instructions on that issue because, of course, on behalf of the father, it has been suggested, well, does that mean her position is changing or she's happy to go there? What the mother has told me over the lunch break in the short time available is that she has been advised that that is what she has to do in case she is returned, that is, if this return order is upheld and she has to go back to Romania, to avoid the risk of Hakim being taken from her and placed with the father. Sorry. Yes, being placed with the father. So it's been a feature that unfortunately the mother is very young and vulnerable, and she doesn't always seem to understand very well the proceedings in Romania. I've also been asked to remind the court that actually her first language is Roma, not Romanian. I don't know whether that causes difficulties as well with legal formal documents, but in any event, as far as she's able to understand it, that's what she has to do, otherwise she's more at risk of losing custody of the child on return. So in a lot of ways, actually, that makes the position on protective measures even worse, because she's being told she's not allowed to keep her address confidential even if she wants to. But of course, that's all at risk of straying into matters that obviously weren't before the court, but given the questions asked before lunch and the further information that's been coming over from the other side, I have taken instructions on all those points.
Thank you. Final point. If we were persuaded by your submissions that the judge's decision is flawed, what do you say we should do?
Well, I think if any of grounds 2A, 3 or 4 were to succeed, then this court would be in just as good a position as the trial judge to make a determination and to say that there should not be an order for this child's return. I would probably have to accept that if the only ground on which I succeeded was in relation to overturning the factual conclusion of the trial judge under 2A, then it might be a case that had to be remitted. But that would only be if that was the sole ground on which the decision was overturned. And in relation to the ultimate outcome. Of course, if it was only under Article 13A, then a discretion would arise.
Yes.
But again, in my respectful submission, this is a case where, given the evidence before the court, the outcome of any exercise of discretion is simply inevitable and would clearly be not to require this child's summary return. And therefore, again, this court would be in just as good a position and ought to make a decision that brings finality for this.
You said under Article 13A, on the acquiescence point?
Yes.
Yeah.
Yes, because if it were decided that 13B were actually satisfied, as argued by the mother, then of course it's not a situation where any discretion would really arise, because if there's a grave risk, then the child wouldn't be returned.
No, thank you very much indeed.
May I assist with anything else?
No, thank you. Yes, Mr. Gupta.
Thank you, Lordships. Thank you, my lady. I'm hoping to be about an hour, if that helps at all. Can I just clarify what my learned friend just said? My understanding, my instructions are there's two sets of proceedings in Romania. One is live and not stayed. That's the father's substantive application for residence of the child. That's been listed on the 5th of February next year for a first hearing. And that was issued on the 2nd of October 2024. The other set of proceedings have been stayed, and these were for urgent relief. They've been stayed pending this court's decision. And you've heard what my learned friend said about the exequatur process, essentially administrative issues, getting a apostilled return order.
So the urgent relief was an application by whom, for what?
Those were, my understanding, for urgent, an application for contact.
By
my client.
Okay.
Yes. And resulted in direction for a welfare investigation. And my understanding is that they've been stayed, but my client's Romanian lawyers are appealing that decision.
Right. And when you say a welfare, the report that's been ordered, the social inquiry report,
Yes.
Under the 96 Convention, that is in respect of the first set of proceedings you mentioned, not in the second.
That's my understanding. That's the state. 234 in the supplemental bundle. I should have said, of course, I appear with my learned junior, this best on behalf of the respondent father.
Sorry,
234 in the supplemental bundle.
Thank you. So
these are the proceedings that have been stayed. Sorry, those are the ones that are not stayed but listed in February.
Isn't there are 4 sets of proceedings. It's number 4 is the live one, which is effectively for interim what we might describe as child arrangements. And they're the ones that are ongoing, and it's in those proceedings, isn't it, that the court has made its direction for a social services report. We can see that on page 235.
Yes, temporary emergency measures.
Exactly. But the primary proceedings, which is number 3, are the ones that are listed, you tell us now for the first time.
Yes, substantive.
In February.
Well, so the application, as my lord says, the application for the report is in the stayed proceedings.
Yes.
I see.
Stayed pending your lordship and my lady's decision.
Yes.
It stayed quite recently, I suspect.
That's the
because
impression one's getting, yes.
I think we've got orders in the collection papers which take us at least as far as the 10th of September, I think. So it's
So that's the up-to-date situation. But if the court requires, if you're not deciding the matter today, if the court requires some further information, then no doubt we can agree a document and send it in.
Right. Thank you. Okay.
And so obviously you have our skeleton submissions, which you'll find at page 45 in the bundle, but there was a perfected and replacement skeleton submission with page references in it, which was sent loosely with an additional final paragraph, which you can now ignore because
Oh, can we? I was going to
Yes.
ask about that.
funding was granted yesterday.
Okay.
And obviously the respondent opposes this appeal. Can I deal out of turn with the grounds of appeal? Because I was going to first deal with the idea that the Romanian court has acquiesced to this removal. In my submission, it's dealt with more than adequately by the learned judge in the court below, which is at paragraph 49 onwards. With great respect to him, we too accept that a court can, in certain situations, acquiesce, but that doesn't meet the criteria in this case.
just out of interest. At this point, I think that specific proposition was conceded at first instance.
Yes.
And Mr. Justice Peel refers to two cases, the two cases that we've been taken to.
Yes, paragraph 49.
Are there any? Presumably that was the result of the inquiries or research that was done by your junior
Yes.
at the time. Are you all satisfied? There's a large number of you now in the court. Are you all satisfied that those are the only cases that would be relevant to the question of whether or not a court, which we know can have rights of custody, whether a court can acquiesce? Are those the only two cases on which that proposition has been considered?
As far as we're aware, in this jurisdiction, I can't say that I've conducted an incadat research on the facts, on this legal proposition. And if you want us to, no doubt we can.
Thank you.
But this, of course, the sequence of this ground, if you go back to the actual grounds, is after the appellant has raised the idea of the father acquiescing. And we respectfully submit that's as ground 2, of course. But ground 3 is that the reigning court acquiesced. In other words, if this court finds, as the court below found, that the father has not acquiesced, then put that to one side. Nevertheless, the Romanian court has acquiesced. In other words, it supersedes the father's non-acquiescence. In my submission, that doesn't work conceptually in a private law matter. If the father has rights of custody, if he doesn't acquiesce, then whether or not the court has acquiesced is another matter entirely, and it doesn't supersede his lack of acquiescence. The only other point I wanted to make, well, two other points were, for a court to acquiesce, surely one's looking at something more fundamental, like an interim leave to remove order, an interim decision that the child can remain in this country, for example. And there's nothing like that in this case. And finally, for the court to make, the Romanian court to make inquiries, welfare inquiries using social workers here or Kafkas workers here, surely that's just a practical step and shouldn't be raised to the level of being an example of the foreign court somehow acquiescing in a private law matter and saying, well, this child can remain in this jurisdiction, and that's a defence under the 1980 Hague Convention. And as Lord Justice Cobb pointed out, of course, the 1980 Hague Convention is firmly in the mind of the Romanian courts, even to the extent of saying, well, no, these proceedings, I think it was proceedings number 4, was it? 3, should not have been brought here in Romania. Your Hague application should be raised in England. The whole aim, of course, of this fellow Hague, 1980 Hague country, Romania, EU country, is to make sure there's no blurred lines. It's very clear how an individual seeks the return of their child from one 1980 Hague country to the other, and that welfare proceedings follow on or in concert with the decision of the Hague court. And unless you want me to dwell on that any further, I was going to turn to the round 2, which is the acquiescence of the father grounds, the argument that the father somehow acquiesced to the removal of his child from Romania to this jurisdiction. I'd ask the court to, of course, look at the context of that appeal ground. And by that I mean to look at what the father was actually doing with regards to the removal of his child. If the court can turn, please, back to the judgment, you'll see the learned judge sets out the chronology from paragraph 15 onwards. When he realises that the mother's removing his son from Romania, he flies over immediately and he remains in Romania. Paragraph 16, 17, obviously there are discussions. The mother's father travels over together with the mother's brother. In paragraph 18 you have mediators, etc. And I'll turn back to that judgment in a moment, but if you please turn to the transcript bundle and have a look at paragraph 17, sorry, page 17, internal page 17, electronic page 18. This is the result, of course, of cross-examination, if I may say so, very able cross-examination by Elena Juni, where she's asking the mother what exactly was going on in her mind when she was talking to the father about her removing the child from the jurisdiction of Romania. And what she says at electronic page 17, internal page 16, just to put it into context. Answer, no, I just ask him if you're not going to come.
Where are you?
Sorry. Internal page, printed page 16.
Yes.
Electronic page 17.
Yes.
In the centre of the page.
Yes.
Answered by mother. No, I just ask him, if you're not going to come back in Romania, I'm going to leave with my son. If you're not coming back, he told me I will come whenever I want, not when you want. I'm not going to lose any money because of you. That's because, of course, he was working in England at the time. And then it flows on with, finally, further over the page, Moylan Jr. asking, but you wanted a reconciliation with father, and he refused. Answer, yes. And further on, it was like his answers by the mother. It was like a refusal for him to come back in Romania so he can have a family. I can't leave with A. But he did not at any point say, yes, you can come to the UK with A, did he? No. He just said the way I told you. And that was the basis of her consent case, because that's what she was running, that because he then didn't stop her from leaving somehow that amounted to a consent, which of course was dismissed by the court below and is not a ground of appeal that's been granted permission in this court. Going back to the, and I'll turn of course back to this transcript in due course, but going back to the judgment, this idea of reconciliation, which is I think the first question of my Lord Justice Cobb, when my friend was right at the beginning of her opening. Paragraph 20 of the judgment. This is going further in time, of course, when there were the discussions using the elders of the community, otherwise called mediators, I think, by the learned trial judge. Paragraph 20. However, this is the centre of the paragraph. However, mother did tell me, which I accept, that her primary aim in the discussions, was to try and effect a reconciliation with father, if possible. And if that's not possible, etc., agree finances. So that chimes with the phone call, the actions of the father, and the subsequent attempts by the mediators to reconcile. It was the mother aiming for that. Now, of course, that we respectfully submit has a ripple effect when it comes to looking at the the Article 13b defence. But just turning back to the idea that the father somehow acquiesced to the removal, well, his conduct, as soon as he realises that his child is being taken, it does not. His conduct is not consistent with somebody who's agreeing or subsequently agreeing to the removal. Page 188 of the supplemental bundle is the short text exchange with between the father and the mother's brother, where he demands A's return to Romania. Again, we say this is post-removal. This is not conduct in keeping with acquiescence. So 188 of the supplemental bundle. Which is quite sort of difficult to decipher, but I think it's the mother's brother on the left and the father on the right, talking about his son and how the mother should stop messing him around. That's at 189. With the brother saying on the left, well, there's no one in England. Why would you go there? Because, of course, he's trying to say that the mother and child are not in England. Sorry to flip around, but if you look at the transcripts of the cross-examination, printed page 24, electronic page 25, Moylan Jr. asks at the bottom of the page, it's clear that in messages your brother...
Sorry, this is 20...
Printed page 24, electronic page 25 of the transcript.
I can't... Oh, yes, got it.
It is clear.
Yes.
But in messages to your brother, father was saying that he did not want A to be in England. Do you agree with that? Yes, he said that. And that your brother actually told father that you were not in England with A. Yes. I don't know why he said that, my brother. Well, it's a lie, is it not? Because you were at that point. Yes, but I don't know why my brother said that. Again, so it's accepted at that stage. Post-removal, father not acquiescing or consenting to child being in England. And so that's the context in which we respectfully submit the court should start at. And then, of course, the question is there really clear, cogent, unequivocal evidence of post-removal consent? of acquiescence.
Do we factor into the chronology that you've just given us the fact that on the 2nd of September, the father issued his criminal complaint?
Yes, indeed, Your Lordship. I was going to refer
Sorry.
to paragraph, no, I'm grateful, paragraph 18 of our submissions, where, I was going to say we, but really it's my learned junior who's written the skeleton argument so comprehensively. Paragraph 18, that's the chronology of the actions that my client took on the ground in Romania. 2nd of September, criminal complaint, application for the return of the child dated 6th of November.
Yes, but the relevance, I suppose, of the 2nd of September is that it immediately precedes the conversation about the alleged deal.
Yes, indeed. And of course, none of these civil proceedings have been withdrawn. Criminal proceedings have, pursuant to the Hague decision and the undertakings my client gave, I gather, have now been withdrawn, which is part of the course, of course, in Hague cases. But these are, again, the conduct is not consistent with somebody who's agreeing to the status quo of his child remaining in this jurisdiction. And the question is the evidence of this deal, for want of a better word for it, really cogent enough? And Morris's submission, the learned judge, who painstakingly went through the evidence, and of course, unlike this court, he heard oral evidence from 3 different individuals and tried to put it into context, make sense of it, to come up with a coherent explanation in his mind as to what exactly happened on the ground. As far as he's concerned, that didn't amount to clear, unequivocal consent. The deal, such as it was and it's always difficult, is it not, if one is looking at intermediaries being involved, where there's no written information and there's no identification of the individuals concerned. It's all well and good to say, well, father didn't produce this, but maybe this is one of those cases where the burden of proof is actually relevant. The burden of proof rests solely on the shoulders of the respondent in the court below to show that no, this acquiescence took place, these individuals were concerned, and this is the deal that was struck. But of course, can't show that. The mediators went back and forth, paragraph 18, between agents, so it's agents on behalf of the mother, her father, who's looking at trying to reconcile, because that was her primary aim. Repeating myself, as said at paragraph 20, and coming up with a potential plan. The father, of course, in his evidence, says this very categorically. This is page 182 of the supplemental bundle. Top of the page. Initially, they tried to discuss the prospect of reconciliation between myself and mother, but mother refused. So he accepts that mother refused reconciliation at that stage. Several proposals were put forward. There's 13,000, which is mentioned there, but B is that he would have to pay 100,000 for his child to be brought back to Romania, rather than use the non-means, non-merits tested legal aid certificate that he has. So he didn't agree to accept or pay any money. But if you look further down, his understanding, paragraph 15, the broad agreement that we reached was that mother would come back to Romania with A, to discuss and agree details of how this would work. That's to say the shared care arrangements, formalised agreement by lawyers. In other words, summary return. Did the learned judge, and before I turn back to the judgment, paragraph 17, while I'm on this page, I categorically deny ever agreeing to A's continued residence in the UK or receiving €13,000. Going back to the judgment, paragraph 23. This is where the learned judge touches on this or deals with this. Those are the two options that I've just read out. He rejected both. He denies having received any money. He says, and I accept that no mention was made to him of power of attorney, etc. And again, the broad agreement that we reached was mother would come back to Romania with A and discuss and agree details of how this would work. Sometimes, subsequently, there was some talk of 3 months with mother and 1 month with father, etc. So, and of course, the timing of this is important because the father does not issue his Hague Convention proceedings until I think it was around about March of this year.
If you look at paragraph 20, where the judge deals with the mother's evidence, and it said that her primary aim in the discussions was to try and effect a reconciliation. That certainly doesn't accord with the father's written statement that the mother refused to contemplate reconciliation. And it didn't appear to be consistent with the mother's evidence. Was that something she referred to during her oral evidence?
I'm assuming so. I'm going to just turn my back for
Sure.
Yes. I'm just looking up the transcript. Yes, it seems to be that's what he's saying. The mother actually told him that. But my client's evidence, in written, and it seems in, written form, is contrary to that.
Because we were taken by Ms. Perrins to where it was dealt with in the mother's evidence, and she was saying it was raised by, as was conventional, I think I've got to remember it correctly, by the mediators. And so it wasn't her primary aim. So the judge, it may not, depends on whether it matters. I'm just asking for your help on this. But the judge was wrong when he said that her primary aim was to try and effect a reconciliation.
Yes, and you see that, of course, chimes with what the father says. Initially, they tried to discuss the prospect of reconciliation. They, the elders.
Exactly. So, the parties seem to be...
Mother refused.
Yeah.
So I don't know whether the mother actually orally said, well, actually, I was seeking reconciliation.
Okay. And the other element that Ms. Perrins took us to was 21, and saying that there the judge seemed to have misunderstood the maternal grandfather's evidence as to what the essential terms were. And she was saying that his evidence was the essential term was we pay €13,000, the father will agree to the child remaining with the mother in England.
Well, in the world where my client rejected all of that, they may be brought to believe that they were cutting a deal, as it were. But of course, that involves evidence from the intermediary. If this was, for example, a mediation, you would have heads of agreement signed by the mediator saying, well, this is what's been agreed. We don't have that evidence. If the court had that evidence, then one could say, well, yes, there is clear and unequivocal evidence of the parties that were part of that mediation agreeing with the mediators and the father acquiescing to the removal, and there being a quid pro quo, money exchanging hands. Money seems to have exchanged hands, but the learned judge accepted that they couldn't. At paragraph 24 at the end, not evidence that the father received anything. It is a bit concerning, of course, that €100,000 was also mentioned when one looks at it from the perspective of what the learned judge thought may have happened, namely that the money may be temporarily or permanently with the intermediaries. But in order for to prove that this was a clear arrangement and that money was paid over to the father, there has to be A, something in writing, and B, one has to be able to follow the money. Well, there's nothing there. And of course, going back to the mother's position, she didn't raise it because she didn't feel that she had the evidence to prove it, which was correct, actually. It was only raised at the first hearing, final hearing, because if you look at the transcript, page 35 electronic, printed page 34, cross-examination by Moylan Jr., where it talks about gypsy culture halfway down. There's no mention in your evidence of it being a payment which showed father's consent for A to remain in England. Yes, this is why I didn't want to say at first about this amount of money, because I knew that no one will believe me, because I have no evidence. So, in the mother's own case, when there's no evidence that the money was actually sent to the father, payment was made to him, how can the learned trial judge say otherwise? And if there has been no contractual payment, then there's no deal. Although my client, very fair in my submission, saying, yes, it was all discussed. A lot has been said about my client threatening the mother, and you've seen those messages between mother and father. If one stands back for a moment, and this may be an unpalatable point, but I'm going to make it. Why is he threatening? Why is he getting so upset if he's acquiescing to the removal of his son to England, if the deal has been struck? He's getting so upset because he doesn't agree to the situation. There is no subjective or objective agreement.
The alternative put forward by the judge in paragraph 26 is that if your client did receive the money, then he deceived the mother's family. That's 2/3 of the way through paragraph 26.
Well, in order for that to be as, I mean, that's quite a serious charge that he sort of defrauded and is on some kind of campaign A to take their money and then to seek the return of his child. There would have to be evidence of that, Your Lordship, and there's nothing there, as the mother just said, pointed out in her own evidence. But moving on that quotation in that paragraph, the father his threatening behaviour, as I said, why is he threatening if a deal's been struck? The power of attorney was not mentioned at the time, and the learned judge accepted that, as I pointed out, paragraph 23. He says, and I accept, no mention was made to him of power of attorney. He said he thought they reached an understanding, etc. So the power of attorney is something that follows on. And again, if this had been a composite arrangement through elders of the community, then these are the kind of details that surely would have been flushed out. Of course, the father had lawyers at this stage. Lawyers in Romania who could have easily transmuted any agreement into the correct documentation. So again, conduct is not the conduct at the time. The context of all of this does not meet the appellant's case, doesn't show really that there's any meat on the bone. And these individuals have the assistance of their families, have the assistance of these mediators. As I said, my client has his legal team in Romania. There would be more than a lost 13,000 euros and the words of the maternal grandfather, because of course the mother herself was not involved in talking to the mediators. And that's why the learned judge says at paragraph 25, having set out very clearly what he was told, that what he hasn't been shown, no overall agreement was reached. And again, where an individual was so upset, a parent is so upset about the removal of his child from home country to another country, surely there would have been more detail if an agreement had been reached. Contact being the classic example. Holidays, etc. Nothing. And the learned judge is correct in my submission to say groundwork was laid, some space, and they did envisage something, but not an overall agreement. So going back to the well-known decision, which of course you know, Re-H, the House of Lords decision, page 179 of the authorities bundle. My submission is subjective intention can't be shown, and so then we're now into the world, aren't we not, of the exception. And that's where I was about to say it's unequivocal. Page 179, there are only one exception, where the words or actions of the wrong parent clearly and unequivocally show and have led the other parent to believe that the wronged parent is not asserting or going to assert his right to the summary return of the child, inconsistent with such return, etc. Well, that's not, the evidence isn't there to trigger that defence in my submission. And whatever the mother's father has said as to his understanding, it doesn't show that that was the father's understanding. I just turn my back for a minute. If we turn to the transcript, going back to what the mother was thinking the mediation, if I can tell you that, was about, we have a number of page references. So page 11.
Sorry, hold on. 11.
Yes, is that printed? Printed page 11. Sorry. 4-page references. We'd invite you to read page 11.
Line?
From line 10 onwards.
Thank you.
This is going back to mid-August, as
Yes.
it seems to me, rather than the...
This is providing the context.
Yes, okay. So page 11.
Page 11, page 16. Which you've already read. Page 17, which
Hold on.
16,
Yes, that's
17 you've
about
already read.
That's also about all the...
That's all, yes.
Yes,
And you've already seen that.
yes.
And finally, page 31,
3-1.
3-1.
So I thought there were four. I've got page 11, 16,
17 and 31.
17, thank you, and 31.
31, this is where the elders get involved.
Right, okay.
To be fair, one should read all the way to the end of page 32. Printed 32, electronic page 33.
Did you say that you wanted to get back with him now? I just said my story.
Yes.
Yeah. And then over the page, I did not want to be with him anymore because he was really aggressive with me. Yes.
But going back to 31, Master Division 1 can see why the learned judge thought that the mother was saying that she wanted to reconcile. There it is, bottom of page 32. Now I just said my story.
Yes.
Either way, in my submission, none of that amounts to, as I said, evidence of where you can look at my client's actions directly. Because, of course, this is the strangeness of this particular case, or uniqueness of this case, where it's going through, in the mother's case, two intermediaries, her father and the mediators, and in the father's case, an unnamed mediator. And they end up with no formal agreement and no formalised agreement. Sorry, I'm repeating myself, but surely that's exactly what would happen in a situation where a gentleman has his own lawyers on board as of September, and he's reported the mother to the police, etc. Surely in that situation he would be making sure that his contact arrangements were in place, etc. And it's all there in a Romanian agreement or court order. And the situation on the ground is diffused. So that's why we respectfully submit that the items that we've set out, Moylan and Julia set out in paragraph 7, which is interpolating paragraph 46 of the learned judge's judgment, paragraph 7 of our skeleton submissions, internal page 3. That's why we respectfully submit that the learned judge in the court below was correct to say that he could not conclude that the father had acquiesced, and that one didn't. That defence was not satisfied. And paragraph 8, of course, in a situation where it seems cash was paid over, although there was no evidence of cash withdrawals, etc. The learned judge was correct to say it's plausible that the money was never ever actually paid by those unnamed intermediaries. And turning to page 4 at the top of our skeleton submissions, Romanian court documents, and you have the page reference there, the supplemental bundle, page 309. Also, Romanian court documents stated, father, claimant, shows that he was offered the sum of 13,000 euros but refused it, and that was then passed on further. Defendant, mother, shows that the sum of 13,000 euros was given in cash to the president of the panel, and that, of course, is the president that one assumes the intermediaries. And you have the reference there, it's page 309 of the supplemental bundle. So going back to our respectful skeleton submissions, we respectfully submit that obviously the detail, the granular detail, is not there to show that this was anything other than a suggestion by the elders, which was not followed through, and it could be that one party thought one thing was being agreed and the other party thought the other thing was being agreed. My client believing that his child would be returned with the mother and they would sort things out. When that doesn't happen, he starts Hague proceedings. So it's post mediation conduct by the very fact that he started his proceedings within, I think it's about 5.5 months or so of the removal. Again, that shows, these are actions, are they not, that show conduct, that show an individual is not just sitting back and agreeing to the removal. And all those items that we've mentioned, as I said, in paragraph 18 of our submissions. The steps the father took in Romania, as well as starting these very proceedings. P&P was, I'll move on to the final ground in a moment, but P&P, of course, was mentioned by the learned trial judge. That's a paragraph 39 of his judgment, and you'll find that decision in the authorities bundle at page 630, Lady Justice Hale, as was. And in my submission, it's perfectly proper and correct that parents try and use ways of agreeing matters, try and seek a compromise, and try and use mediation, of course, try and use the elders in the community. But that shouldn't be held against an individual if agreement is not reached. That shouldn't be held against him when he or she seeks a Hague Convention return. They've paused, tried to sort things out, hasn't worked. The couple should be, the parents should be congratulated on trying it, but unfortunately it didn't work out, and that's why these loose ends resulted in the Hague Convention application being made. And the mother not having, in her own words, not having the evidence to show that really agreement was reached, money was paid, etc. Turning back to the final ground, unless your lordships and my lady want to deal with any other aspect of the acquiescence grounds, I have to ask the court to bear this in mind, which is at page 72 of the appeal bundle. core bundle, which is Mr. Justice Peel's short summary of the application for permission to appeal, the N460. And Marcus is absolutely correct. There is, as I understand it, no challenge to the legal principles which I applied. The challenge is to my findings of fact and evaluation. And that is essentially the nub of it. In Marcus' submission, it's quite a high bar for learned friends to achieve in this particular case. He, having heard oral evidence, having sifted through the text messages, etc., and having come to a, for want of a better word, holistic understanding of where everyone stood at the time, and subsequent to child's removal from jurisdiction of Romania. And his findings are incontrovertible, unchallengeable, apart from certain aspects, such as the one that I just identified, when it comes to was the mother going into mediation thinking she wanted to reconcile. One could see why he would think that because of the way the questions were put and the way the answers came out. But actually one can pick up on other aspects which show that she didn't, but that doesn't necessarily affect, fatally, his overall decision in this matter. Article 13b. Now, my client, of course, comes from Romanian background, and he tried to use culturally appropriate mediation methods. He has, on his own evidence, if I can just turn it up, bear with me one moment. Page 133 of the supplemental bundle denies the mother's allegations, unfounded, have no evidential support. I have a copy of my criminal record and the address of the police to which I belong confirms there is no complaint against me. I have no criminal record. I'm not known to be a violent person or have problems with the law. I supplied this to my English lawyer. Having said that, of course, this is a Hague Convention case, so one has to take the allegations at their highest, and the learned judge did not misdirect himself with regards to the law in that respect. But one has to have a weather eye on the right to individuals of a fair trial, the fact that they're innocent until they're proven guilty, and that the court has to be realistic when it comes to protective measures. To say that my client found the address of the mother so that the tipstaff could serve the order does not show that he's a risk to her. Far from it. The tipstaff, my understanding is, they tried to execute the tipstaff order that was made on the 17th of April, but they were not successful. So a further order was made to execute the location order on the 9th of May, and my client found the address on the 10th of May. He's the father of a abducted child. He doesn't know where the child is. He makes inquiries using the method that, ingenious method of Google mapping, telephone contact, FaceTime contact. He gives that address to the tipstaff, who then go and execute the order. He doesn't fly over to England and execute some kind of threats to kill or execute the mother or anything like that. He's gone through the correct procedure and process. He's used mediators, he's used lawyers, even though he knew, before the tipstaff even knew exactly where the mother and child were. So in my decision, one has to get real, and the court has to understand what exactly is a risk and what is not a risk. And just because an individual raises all these heinous allegations does not mean the court on a domestic level would necessarily automatically agree with them. But of course, in the grounds of a convention case, the learned judge at paragraph 65 says what? These complaints and assertions are very grave. I've set them out above. They seem to establish at least potentially £30 million. So he does take them seriously. These are summary proceedings. Just because he doesn't set them out slavishly does not mean he hasn't taken them on board. He's trying to figure out a workable solution where the child can still be returned summarily by the abducting parent to Romania and be safe over there. And in a situation where the father knew of the address in England and no harm came to the mother, even if he's able to know her address in Romania, we respectfully submit that doesn't mean that will be a risk to the mother in Romania. And what he then does, of course, at paragraph 73, is that he sets out the protective measures that would scotch or satisfy the Article 13b defence, paragraph 72. The Article 13b defence is not made out, provided the protective measures are in place. I'm moving the syntax around. And so, consequently, one doesn't even get to the discretionary exercise. And the order, of course, is quite clear. If you look at page 67 of the core bundle, paragraph 7, return of the child conditional upon, and it's paragraphs A to D below complied with. Child won't leave this country unless A to D are complied with. Of course, there are further protective measures that are set out in paragraph 8. But A to D, in Master's submission, covers the immediate situation to make sure not only is there a soft landing, there's actually a safe landing for mother and child. And of course, he's not saying that he'll return with the child or that he's going to remove the child from mother's care. He's actually allowing her to return. He's managed to obtain written confirmation from the prosecutor's office, trying to, but I gather that it is confirmed, as far as my instructions are concerned, that the criminal complaint has been withdrawn, and of course the costs that set out in paragraph B and C are payable, and paragraph 9 is what's referred to in paragraph D. Paragraph 9 being the order stayed until this order is registered with the Romanian court. And you've heard earlier on that that's an administrative issue with regards to getting the order apostille, because we can't get the wet sealed version from this court, which is no doubt coming, to enable the exequatur process. These are all the actions, in my suspicion, of an individual who is abiding by court procedure, who is dealing with the matter with integrity and through lawyers, and who, my suspicion, didn't at any stage prior to or subsequent to the departure of his son from Romania agree to that removal. And of course there is this initial hearing in February of next year, which is now not that far away. And that'll be the forum, the correct forum, our submission for the mother to be able to put her case forward as to why it is that she should be leaving the jurisdiction of Romania with her child. Although, of course, one has to go back to that point in the transcript, which I mentioned right at the beginning, where she said, I think it was 17, but you wanted reconciliation with father, and he refused, yes. And that was her original reason for her phone call all those months ago in August of 2024. If you're not going to come back to Romania, I'm going to leave with my son, is what she said. Well, that's exactly what the father's seeking now, for child to be returned to Romania with mother. And instead of there being this immature and harmful response on behalf of the mother, the matter can go through the Romanian courts, who are ready and able to deal with the matter very quickly in Marseille's submission. It may be, of course, that the emergency procedures that we identified earlier on, the emergency procedure can be unstayed. There'll be a hearing earlier, sooner rather than later, because those are the proceedings that are stayed pending the decision of this court. Can I just turn my back for a minute? Yes, our understanding is, of course, if the appeal is dismissed, the mother would indeed return with the child. There's no issue about that. I'm just turning over my friend. I don't think there's any issue about that. And my client's not seeking mother and child to be divided at any stage, but simply that the child to be returned so that the Romanian courts can get on with matters as quickly as they can in the circumstances. If I can just check my notes, see whether there's anything else. Are there any questions that my lords or my lady have?
Well, the same question I asked Ms. Perrins. If we were to decide that the judgment is flawed in respect of any elements of the matters advanced in the grounds, what do you submit that we should do?
In my estimation, it should be swiftly remitted to the court below for a 2-day hearing with oral evidence and a direction, possibly, that there's evidence from the elders of the community, but that's if the court wants to grant the appeal. But we say that's a fundamental weakness in the appellant's case in the court below. There was no proof, as I said, of the agreement being reached or even being communicated to the father.
And you're really saying that it would need to be remitted, in particular I take it on acquiescence, because we can't hear oral evidence, the judge did, and it'd be right that there should be oral evidence again.
Yes, because it's a conflict of fact. The court would have to come to a factual determination on oral evidence. Can I assist your lordships any further?
No, thank you very much. Thank you.
Very much.
Yes, Ms. Perrins.
Yes, just a few points in response, if I may. First of all, my learned friend said that the father's interim application in Romania is for contact, but the father has applied for custody of A in both of his applications in Romania, so both in what's been termed as the temporary or emergency measures case number and in the substantive welfare proceedings. So in both of those cases, his position is the child's main residence should be with him. What he says is that his alternative position is that if he doesn't get that, he seeks child arrangements. And he was also clear in his evidence to the judge that his position is he wants this child to be with him. In relation to acquiescence by the court, I can confirm that Moylan Jr. did trawl through the INCADAT database.
Right.
And she was able to identify cases which recognise the concept of a court holding rights of custody, but she wasn't able to find anything that found acquiescence by the court.
Right, thank you.
So I'm afraid we can't assist further on that.
Yes.
And
Well,
in
no,
time,
that is of assistance.
Yes, so in the time available, we haven't been able to identify any other cases other than those that are in
Right.
the bundle.
Thank you.
But in terms of the concept, Moylan and friends suggested that it doesn't work where there is a father, as in this case, who does not acquiesce and is still saying they want the child back. But in my submission, conceptually, it does still work, because if the example of this would be, say that there was actually a specific order that we would call an interim leave to remove permission, but the applicant parent in the Hague proceedings here was obstinate and insisted that they were still entitled to pursue their Hague Convention application, and they refused to withdraw it. It's actually not clear what would be the procedural vehicle for the English court to then dispose of the application, even though obviously it should if such an order were made. There are examples in case law of, for example, an ultra-summary dismissal of a Hague Convention application, or it might be said it was an abusive process of some sort, but of course under the family procedure rules one cannot apply to strike out any application to which Part 12 relates, which would include Hague Convention proceedings, so children proceedings in essence. So strikeout's not an option.
I think you might say, if the court had made an order, this is thinking aloud, which often is not wise, that there would be no breach of the father's rights of custody in any form if the court of the child's home state had given permission for the child to live temporarily in the other state.
Pragmatically, that would make sense, but our law is that wrongful removals or retentions happen at a particular point in time. They're not a continuing state of affairs. And so if the interim leave to remove came later, that doesn't quite work either. So that's why in my submission, actually, the most pure or principled way to address it is through Article 13A.
I think
So
our law
there's been
might have to
acquiescence.
develop if that was an impediment to try and make it coherent. But yes, an interesting debate for another day.
Yes. Moving then to the points made about the evidence on acquiescence. First of all, I already referred this morning to the point about reconciliation, and when Moylan and Friend was referring to the mother's aim of reconciliation and took you through the transcript there, as I think my Lord Justice Moylan observed, that was relating to the consent phone call, which was
Yes.
on the 12th of August and before they left
Yes.
Romania. That was the point where this relationship finally ended, and the mother then went back to England. That is a completely separate point in time to the discussions with the elders, and the mother's evidence, both in her written statement and then when she was questioned about this in cross-examination, was that it is customary to be asked, first of all, will you reconcile? But she said no. And so it wasn't correct when the judge said that that was the mother's primary aim when it came to the deal that was struck post-dating the child arriving here. The father's conduct and his objections and his actions in Romania in terms of making the criminal complaint and also issuing the proceedings there, in my submission, those factors are not so relevant in the present case, because this is a case where it is likely that all along the father was tricking the mother's family. And so, although he signalled his agreement to the €13,000 deal, he was always deceiving them. And so, in that scenario, it doesn't actually provide a problem or an inconsistency for him to have done the things that he did. Also, of course, the fact that he had made the criminal complaint really could be seen as another aspect of his leverage over the maternal family, and all arriving then at his first proposal in a phone call in September 2024 to the grandfather, that they should come to Romania and pay him a sum of money, and on that basis the child would stay here. In relation to that criminal complaint, just as a side point, which goes really to Article 13b, in the judgment, one of the protective measures is that there needs to be further evidence obtained directly from
Yes.
the Romanian prosecutor about the withdrawal of the criminal complaint, because on the evidence before the judge it wasn't clear, first of all, precisely which complaints, if any, had been formally withdrawn by the father, or secondly, on the advice of the SJE, that definitely would remove all risk of arrest to the mother on a return. As far as I'm aware, no further steps have yet been taken in that
Thank you.
regard. The submissions about the lack of written evidence from the Roma elders, in my submission, is another example of seeking to put our own cultural norms or legal approaches onto what is quite a different and specific cultural situation. And indeed, there was evidence from the mother and the grandfather that it was a stipulation of the elders that there could not be any notes taken of the proceedings between them by either party who was involved, and that's just the way that they do things. But that doesn't mean that there is no evidence of the deal. It's just that that is how it proceeds in this particular customary forum.
As I understood it, that was not to prevent the elders themselves from making notes, and indeed they did. I think. That's recorded.
Yes, in the maternal grandfather's evidence, he told the court about a notebook which he saw the elders using.
Yeah.
But very specifically, he was told, you aren't allowed to take notes, and you're not allowed to have it. But that doesn't mean, of course, that the grandfather and the father and the mother can't all give their own evidence about what they understood through these discussions, and that's just the nature of this particular case. It doesn't mean that there was no relevant deal struck. The father's evidence that the mother would come back to Romania to discuss shared care, and also the reference to the proposal of €100,000 to bring the child back, it's important to point out that those suggestions only came from the father in his witness statement in response to the evidence about the September deal. So that was not something that the mother or the grandfather said, and neither of them accepted that they'd ever proposed being paid €100,000 to bring A back. That was, on their case, an invention of the father. Also, just on that point, if the judge had rejected the evidence of the mother and the grandfather that the money was ever actually paid, then it would have been one thing to accept that maybe all that was struck was an understanding that they come back to talk about shared care. But of course, that was not consistent with a finding that the money was actually paid, and also, according to paragraphs 21 and 22 of the judgment, it was accepted that the elders told the grandfather that father had agreed to the €13,000 deal for aid to stay in England. Moylan and Friend said that there is the lack of a formal heads of agreement, or that there was no formalisation of this contract. Well, again, that really feeds into the point I just made about seeking to impose our own norms onto the present scenario, and there's obvious evidence about why that's not how these things are done, and it doesn't detract from the evidence of the mother and the grandfather about the deal that was struck. On page 35, I think it is, of the transcript as well, the mother was cross-examined about the timing of her disclosing the deal and the fact that she hadn't previously mentioned it, and Moylan and Friend also referred to the mother's explanation that she said that she was worried she didn't have evidence of the financial transaction and that it wouldn't be possible to rely on it. But of course, that doesn't mean that in formal legal terms she was accepting there was no evidence of the deal. As lawyers, we all understand that the evidence can include witness statements and each party's own oral evidence and accounts of what has happened, and indeed that's what was then put before the court in this case. Also, although the mother had to accept that she couldn't show exactly a bank transfer or similar, there was documentary evidence of a circumstantial nature which was produced. So, for example, at Supplemental 174, there's a screenshot of text messages between the grandfather and one of the Roma elders, and you can also see that there are logs of several calls being made, again because the elder's preference was to do everything verbally. But there is one text message where the grandfather asks, why has, I think he's called Padukan, requested this amount? And there were flight logs, and in any event, the father, when he responded, accepted that this discussion had happened. So really, it doesn't help the father to say that that the mother didn't mention this before, or that every single part of it isn't documented. In relation to the evidence of deceit, Moylan and friends said there's no evidence of deceit. Well, of course, the deceit is just in the facts of the case, that the father agreed or said that he agreed to this deal, led the maternal family to believe that they had this deal, but then immediately went back on it. But actually there was also express evidence that he had tricked them, because the grandfather said that in a telephone call shortly after the money was paid, the father did say to him in terms that he'd tricked them. He'd had, I think the words were, he'd had the money and he'll have the baby as well. And the mother also referred to that in her witness statement. So there was direct evidence that the father had intended to trick them all along. And indeed that part of the grandfather's evidence wasn't challenged, and the judge essentially accepted it, although it's fair to say that the paragraph where he refers to that, he doesn't make specific findings about all the words that were used, and he says he has some doubt about the words that were used. But again, that's not really a fair comment when the grandfather wasn't actually challenged on that particular part of the chronology, and he wasn't found to have lied about anything else. Moylan and friend referred to the evidence in the Romanian proceedings. I should just make clear again on behalf of my client that for whatever reason on this side we've had extreme difficulty in obtaining documentation from Romania, and I cannot say on my client's behalf that we're confident that everything that was in the bundle, the so-called Romanian bundle for this final hearing, was complete. But in any event, the evidence that was given by the grandmother doesn't detract from the case, because it establishes that the €13,000 was paid, but this isn't something that was directly covered by the judge, because of course it wasn't the grandmother who was giving evidence in the English court, it was the more directly involved people, the mother and the maternal grandfather, Mr. B. Going back to the case of P&P, which my learned friend referred to, the final passage, or the key passage which is relied upon in the decision of Mrs. Justice Hale, as she then was, as I must always say, is at tab 7.
Yes.
And page 187 of the authorities bundle.
Yes.
And I was just going to draw attention to the very last sentence in the top paragraph on that page, which is having referred to the scenario where parents are having negotiations. She says, they, as in parents, should not therefore necessarily fall within the exception or necessarily lead to the conclusion that as a matter of fact there was a subjective state of mind that was wholly content for the child to remain here. So even on the decision in P&P, it's not a blanket decision that says you can never find acquiescence where there's been some sort of negotiations. Then in addition to that, I would draw the court's attention to just some practical examples. So in the case of Re LS, which is tab 14 in the authorities bundle, probably don't need to go beyond the head note because it's just a short point about the facts, but that
Yes.
was an acquiescence case where there had been a formal written court order or agreement in the USA after the abduction had happened, and which gave the mother sole custody of the child and also provided for holidays, apparently on the basis that the child would be in England. But the written agreement did not say in terms she is allowed to stay in England, or that the father agrees to that or acquiesces in that. But in that case, the trial judge's decision was overturned, and it was held that the agreement did amount to acquiescence. There didn't have to be those exactly express words contained in it. When looking at the circumstances as a whole, it was obvious, everyone knew what the situation was and where the child was, and in those circumstances, custody was given to mother. An example of perhaps an even less clear course of conduct is in the more recent case before Mrs. Justice Leven of CH. And in that case, there had been...
Sorry, where's that?
Sorry, that's tab 16.
Thank you. Yes.
And it is a very lengthy judgment on the facts, and so, if I may, I just want to try to summarise the point briefly as I'm looking at the time. But in that case, there had been not just a single document like in RELS, there had been a whole course of communications between two parents, including text messages and proposals. And essentially, the judge found that looking at the case as a whole, the father had acquiesced, and one of the reasons that she found that was because in his proposals to the mother, the father had never said that he wanted the child back in Spain, nor had he indicated in the way that he made the proposals that he disagreed with the child staying in England. So it was an absence or a silence, if you like, on the point about where the child would be that really led to him losing on the acquiescence point. So I'm drawing attention to those examples just to show that sometimes discussions or negotiations certainly can amount to acquiescence, number one. But anyway, really in this case, we are in a factual scenario that goes way beyond discussions or negotiations or seeking to interpret a letter or a proposal, because of course the evidence was that the discussions finished and the money was paid, and I've already addressed at some length what the whole point of that money being paid was. So that was a finalised deal, and so it's not really the same as these negotiation cases anyway. It's quite a simple and straightforward factual case actually, rather than having to analyse reams and reams of text messages and other letters, etc. Just three short points on Article 13b, as I've probably covered most of this ground already. But first of all, in relation to the protective measures, the position for this mother, based on the further information about what's going on in Romania, actually appears to be even worse so far as keeping her address secure is concerned, because if she's been told that she needs to, or has felt that she has to go back to the grandmother's house, well, all of the risks from the father and the threats to kill towards the mother and all of her family members and the other forms of aggression are clearly much more heightened. The point about the list of measures, Moylan and friends said that this is, I think he said this is evidence that the father is dealing with things properly or with integrity, but of course the list of measures was at least on some points imposed by the court, so not everything that is included at the end of the judgment and incorporated into the order was by consent from father's office, although I accept that some points were. It's said that something should be read into the fact that he had or has always had a lawyer in Romania and never referred to the agreement through the elders, or that it shows he wants to do things properly and didn't acquiesce. But of course, the elders and their little discussions that they had were not part of the formal court procedure. It was a completely separate thing. And the fact that the father has had always this case running against the mother in Romania and has refused to give assurances, for example, that he will not try to remove the child from the mother on an interim or urgent or short notice basis, speaks volumes and is a real concern. Allied to that, as I say, there has been a real problem on the mother's side with her either understanding or being able to produce proper documents and to deal with what is happening in the Romanian court, and she's just going to be even more vulnerable if she is sent back to Romania in these circumstances to face all of that, living in her grandmother's and without proper protection. I've probably already addressed at length the particular measures and why they don't address all the risks to this mother and child, but just one final point about the father's offers or what might happen once she gets back there. He has confirmed, both in his own court documents in Romania and then again in cross-examination, that his position is he wants to remove the child from the mother, and in addition to that, it ought to be considered in light of the mother's evidence about the really quite sinister and upsetting evidence that A, was taken out of her care and control when he was a young baby. She wasn't allowed to breastfeed him, and also that the father and his family at times made comments to her to the effect of they'd like to get rid of her but keep the child. So all of that is important factual background and context when considering whether this list of measures at the end of the judgment can possibly protect the child in the circumstances of this case. Finally, in relation to the question about remitting, I just wanted to make clear that, if I may turn to the grounds of appeal quickly, which are at page 16.
Yes.
So I accept that if there had to be a reconsideration of 2A,
Yes.
so the factual conclusion that there wasn't acquiescence, then we may be in the territory of having to remit the case. But if the alternative 2B ground were upheld, that the findings as made should in any event have been held to meet at least the Re-H exceptional basis, then of course there wouldn't be a need to remit the case because there wouldn't be a need for any further evidence or findings to be made. And as I think I already said, if any of the other grounds are successful, then again I would invite this court to substitute its own decision, and that would be quite proper and possible in this case, I would say.
Thank you.
May I just turn my back for a moment? May I assist with anything else?
No, thank you very much indeed. Well, thank you all for your respective submissions. We are going to reserve our judgments. They'll be provided to you in draft for the usual limited purposes to just correct typographical errors. And we would hope that once you've received them, you will be able to agree a draft order, but if not, we'll deal with anything outstanding on paper. So thank you again. Thank you very much.
Court rises, April.